Members of the jury, the claim of the plaintiff is that while the defendants were the owners and in control of this apartment house, the infant resided in the house with the infant's parents and the family, and that on the 19th day of April, while the infant was in the yard of the apartment house, a large piece of cornice or other substance which has been referred to in this action as a piece of coping fell from the roof of the apartment house onto the infant and struck the infant on the head and back and caused the infant injuries, out of which certain conditions have resulted for which the plaintiff claims damages in this action. These claims by the plaintiff, with the exception of the ownership and control of the premises by the defendants, are denied by the defendant, and an issue of fact is thus raised, and upon that issue each side has brought forward certain evidence by the testimony of witnesses and documentary evidence that has been offered as exhibits in the case. A question of fact is thus presented which the court is submitting to the jury for determination by the jury. You alone are the judges of the facts, and you will find the facts in the evidence and testimony of the case. You are fairly and impartially to consider the evidence in the case. Any evidence which was offered but excluded by the court is to be given no consideration whatsoever. Inferences that fairly and logically flow from the facts and circumstances proved in the evidence may be drawn by the jury. The jury alone are the judges of the credibility of the testimony and the weight to be given to the testimony of the witnesses. You may consider the witness's appearance while on the stand. As shown by the evidence, the jury may consider the witness's interest, bias, or prejudice, the witness's character and intelligence, and particularly the witness's opportunity of acquiring knowledge through the use of the witness's faculties concerning matters on which the witness gave testimony. The jury may consider the probability or improbability of testimony in the light of the juror's everyday knowledge and experience, and any appearance or circumstances which to the members of the jury indicate truth or falsehood as to any material fact, that is, one necessary to the determination of the issues. If the jury finds any witness has willfully and purposely, or with intent to mislead, testified falsely, the jury may disregard such witness's entire testimony, if such fact is not material, but the testimony of it untrue, or if the fact is material and the witness's testimony not knowingly or willfully false, but unintentionally incorrect or untrue, or erroneous, or the result of honest mistake. The jury may consider this in deciding the weight or credit to be given to such witnesses' testimony. The jury may consider the interest, that is, the probable gain in the event of success or loss in the event of failure, of a witness or party interested in the event. The fact that a witness is interested or has some reason other than a mere desire to see justice done between the parties does not of itself make the witness's testimony untrue or unbelievable, any more so than the fact that a witness is disinterested of itself, unless the witness's testimony is wholly true or believable. Interest or disinterest may be considered by the jury in determining how much weight or credit the jury will attach to the testimony of the various witnesses. The jury may consider an opinion given by a medical expert or a physician giving testimony upon a trial. In order to consider an opinion given by a physician, the jury then accepts as true the facts upon which the opinion is based. And if the jury finds that the facts upon which the opinion is based are not the facts as they are determined by the jury, then the jury should not give consideration to the opinion. An opinion is entitled to such weight and credit as the jury finds it to be entitled to after a consideration of the opinion, and also a consideration of the witness's general knowledge on the subject concerning which he is giving testimony, his knowledge of the facts in the case, his opportunity for examination of the facts with respect to which he testified, and the sufficiency of the reasons given. $150.